I'm now going to invite Dominic to tell us about what's been happening in, as I say, the ever-changing world of coronavirus regulations. Dominic.
Thank you very much, Andrew. Well, there's been quite a bit happening, as pretty much everybody will know by now, particularly this week, where knowledge of the law has become rather newsworthy. I'm not going to get into the detail. You may be overjoyed, you may be disappointed to find out. I'm not going to get into the detail of all the various regional local lockdowns. New restrictions in the north I saw were announced today. I am going to touch on the principle, however, but this update is primarily going to be concerned with the nationwide restrictions in those regulations you see referred to on the page there. And I'm also going to touch upon the new requirements to self-isolate. The law is, as was in force yesterday, unless I specifically make reference to it being revoked. By the time I finish this webinar, it may all have changed, but that's the nature of it. And the usual caveat applies there, the link there to the guidance to follow. So we start with the specified purpose of the regulations. Touched on this before, of course. It's always worth referring back to it, though, because it's against this test that all of the regulations are judged. And it's against this test that they're all reviewed, required to be regularly reviewed. And if a particular provision is no longer necessary to meet the specified purpose, then that regulation must be terminated. And that's relevant, particularly when we come to look at local lockdowns and the regional variations in them. There's a sunset clause on these regulations 6 months after commencement, which would take us to the 3rd of January. The new concepts we're going to be looking at in this webinar, or at least new to the webinar series, are local lockdowns. As I've already said, I'm just going to be looking at principles, not the varied detail of them. I'll look at the general rule or the nationwide restrictions in detail. We're also going to be looking at linked households, which is a concept that's been in force for a little while, but it's the first time that I've discussed it. And then finally, we're going to look at the legal requirement to self-isolate in those recently made regulations came into force just earlier this week. So starting with local lockdowns, they were first introduced, this concept first introduced in Leicester on the 4th of July and subsequently rolled out in various areas of the northwest, northeast, the Midlands, and so on. On the 4th of July, of course, by and large, the restrictions were being eased across the country, but Leicester was made an exception, the first of various. So these are regional exceptions to the general rule or the nationwide rule that's contained within the regulations that we're looking at today. There's a concept of a protected area, which is what's used in those local lockdown regulations to define the scope of that local lockdown. Broadly speaking, it's defined with reference to postcodes. Of course, again, as we've seen this week, the local lockdown restrictions are not one size fits all. So the measures are varied between place to place. And so some things that are permissible in one location are not in another, and vice versa, but there doesn't seem to be a scaling of them so that you're either at category A restrictions or B or C or so on. And I'm going to look at an issue with that in a moment. The variations that we've seen have included no opening of bars and restaurants and so on, or having restricted hours, restrictions on gatherings that are more onerous than the general nationwide rule, no overnight stays outside the home, or no social visits to other residences. And so there are obviously different degrees of restriction. With the variation, of course, comes the problem of complexity. And that arises because there are two competing principles at play when formulating regulations for local lockdowns. On the one hand, of course, the restrictions in a particular area should be no more onerous than necessary for the specified purpose. That they wouldn't be permitted within the regulations, of course, and that's the proper approach from the perspective of civil liberties. Equally, bespoke restrictions represent a targeted public health response. It's appropriate to tailor the restrictions to the situation in that particular area. Against those principles, however, is this: the advantage of the severe restrictions early on was that they were clear. Stay at home, don't go out unless you've got a reasonable excuse. That was clear, and it was one size fits all across the country. And so the problem with these regional variations is the problem of lack of certainty in the law. It's a problem of legal authority. It's a problem potentially of legal certainty with Article 7 implications. But it's also, more importantly, probably, when looking at the specified purpose, a practical problem. Because if people don't know or understand the law, they can't comply it. And that's got consequences not just for not just legal consequences for that individual, but also, of course, public health consequences for those that the law is designed to protect. So how do we fix that? Well, obviously it would be somewhat surprising if I had all the answers, but here are some suggestions that might assist when thinking about how to solve the problem of lack of legal certainty. And the first, of course, is the announcement of the new restrictions in a predictable, reliable way. So not sort of trailed in the press or leaked later today in the north, such and such is going to be announced. That's not helpful, it's not clear. Secondly, clear publication of the restrictions. And until recently, so far as I could tell, the law hadn't appeared on the guidance page, or the link to the law hadn't appeared on the page that I linked to on the first opening slide of these talks. And so that was unfortunate, and you'd have to go ferreting around if you wanted to find what the law was. Obviously, we've all done a bit of that. It'd be helpful to have the clear link to what the law actually is in the same place as the guidance. Early liaison with responsible authorities. The police we've seen in the last week or so and before that have been saying, look, they brought in these restrictions, we didn't know what they were going to do until they were already in force. That's unhelpful. But probably a more sort of categorical, slightly more radical perhaps solution would be to have banding or categorisation of the regional restrictions. So less variation, and yes, necessarily a less bespoke, tailored approach, but a grading system or a banding system so that people could understand if they are in an area that is under category A restrictions, then that they contain the following. If they're category B, then this is slightly more severe level of restriction, category C, and so on. Something like that might be more helpful in terms of compliance, which ultimately is the aim, compliance and pressing down the rate of transmission of the coronavirus. It may be assisted by a banding system such as that. We shall see. Equally, there are arguments for the bespoke targeted regulations. So that's all I'm going to say about local lockdowns, simply to touch upon them conceptually and look at some of the legal issues that might arise. Going back now to the nationwide regulations, the more general restrictions. And one of the cons, the downsides, of course, of clarity, just to remind ourselves, in relation to restrictions on movement, the general rule as of the 26th of March was don't leave your house without, of course, a reasonable excuse. Gradually modified, as you see on the page there, revoked in its entirety on the 4th of July, and the focus then shifted to the gathering restrictions. But that's where we started in late March with a very clear rule that was nonetheless a very severe restriction on individual liberty. So now I'm going to be focusing on the gatherings restrictions, because that's where the changes have by and large been happening since July nationwide. We've looked before at what a gathering is. Essentially, it's whenever two or more people come into contact with each other for any purpose. It's a catch-all term. It'd be hard to associate with someone and it not be caught by that regulation. This slide shows the development of the restrictions. We started off in March. You could have two people in a gathering outside, but of course there was a limited excuse or limited basis to leave home at all back then. That was relaxed, 6 outdoors, no indoor gatherings of more than one person, subject to exceptions. In mid-June, the linked households concept was introduced, and I'm going to deal with that in a moment. And then on the 4th of July, there was a wider relaxation of this restriction to allow up to 30 people to gather for any purpose, and there were exceptions permitting larger gatherings. And the restrictions, of course, are tightening again now, or have recently. And so the current position is what's become known conveniently as the rule of 6. So that is a rule that no more than 6 people can meet for any purpose unless one of 3 categories of exception apply. Breach of this regulation is a criminal offence, as it was before. The only change there really is that the level of fixed penalty notices has been doubled. So the starting point is £200 instead of 1, and it then doubles thereafter for second and subsequent offences up to £6,500 or so. So, general rule, the rule of 6, we see that nice and clear. The exceptions are slightly more fiddly, so we're going to go through them a little more slowly. So the first category of exception under 5.1a relates to linked households. What are they? Well, they're defined by Regulation 5ZA. It's amazing, isn't it, how recently the regulations have been enacted, and already they're using 5ZA to describe the new provisions rather than a standard numerical system. Shows the rate of amendment, I suppose. 5ZA is up on the screen there. Essentially, what a linked household is a situation in which a single adult or single parent of an under 18 or more than one under 18s can choose to link with another household of any size if that other household agrees. They will then be treated as one household for the purposes of Regulation 5. They have to remain exclusive. You can't be linked to one household one day and another household the next, otherwise that defeats the purpose, obviously. But a single parent or a single adult can link with another household of any size, and they are then treated as one entity, one household effectively, for the purpose of Regulation 5 and other regulations. And so more than 6 people can gather together for any purpose if they are in linked households, or indeed if they're all from the same household. So the second category of exceptions is a bit more involved. Regulation 5.1b relates to people participating in qualifying groups, come to what that is, in gatherings that are covered by either Regulation 5.2 or 5.2a. Regulation 5.2 there is a gathering taking place on essentially business premises or premises operated by charitable, benevolent or philanthropic institution or public body. Gathering 2A is similar but relates to gatherings organised by a business, etc., in a public outdoor space, and the gathering organiser complies with paragraph 5G. And we're not going to look at 5G, but 5G relates to conducting risk assessments and ensuring that all reasonable measures are taken to reduce the risk of transmission of the coronavirus. Okay, and that crops up quite a lot in these regulations. It's a burden on the organiser. So if you're participating in a gathering as part of a qualifying group in either of these settings, on business premises or outdoors in a gathering organised by a business, then you can gather as a group of more than 6. What's a qualifying group? Here we are. It is a group of no more than 6 people, or a group of more than 6 people who are members either of the same household or of 2 linked households. You can't mingle with other groups at the gathering if you are a member of a qualifying group. What does all that mean in practice? Well, this has really been designed, it seems, to allow you to go to premises where there are going to be a lot of other people, broadly speaking, doing the same thing, but where you are not associating with those other people, you're not mingling with those other people. And so the standard example is you can go to the pub on your own, or you could go to the pub as a group of up to 6 friends from different households, or you could go to the pub as a group of more than 6 people, provided all of your group are just within 2 linked households. Once you're there, no mingling with the other guests is the rule. So, and that is what those exceptions are about. And the 5.2a exception is broadly the same as that, relating to gathering in a public outdoor space, subject, of course, to the organiser having conducted a risk assessment and so on. So that's that category of exceptions. And then finally, exceptions to the rule of 6 are the Regulation 5.1c exceptions. And this is a list broadly similar to the ones that we've probably become a bit familiar with over the last few months. So if you're an elite sports person, if you're watching this webinar, my hunch is that you are not. That might be unfair. If the gathering is reasonably necessary for work, education, childcare, and so on, you see there set out examples, but that is very much a list that we've become familiar with. You could gather as a group of more than 6 to fulfill a legal obligation, or as part of a support group. We'll look at that in a moment. A support group consisting of no more than 15 persons and not in a private dwelling. You could gather for a marriage ceremony or reception consisting of no more than 15 persons and not in a private dwelling. And for a funeral at specified premises, you could gather as a group of no more than 30 persons. Further specified exceptions, you could gather now explicitly for the purposes of protest, where the gathering has been organised by a business, etc., and the risk assessment has been complied with. In relation to political body, it's referred to there. There's a previous webinar, an update in fact, that I did back in July that covers what that means or what may mean. You could gather as a group of more than 6 if you're participating in an outdoor sports gathering or permitted indoor sports gathering. We'll look at those definitions in a minute. You could gather as a group of more than 6 happily in criminal justice accommodation. And I can only think the purpose of that is to allow prisons to accommodate more than 6 people. They've obviously concerned that people might be committing a criminal offence by being imprisoned with more than 5 others. Presumably you have a fairly good defence to that, even if the exception hadn't been drafted specifically for you. You could gather if the gathering's outdoors and is for the purpose of a relevant outdoor activity, and if the organiser complies with the risk assessment, paragraph 5G. And the way in which relevant outdoor activity is defined is with reference to activities needing a licence to either perform the activity or to hold the equipment needed in the activity. And the only obvious example that I could think of, which has obviously been touched upon in the press, is going shooting. So again, a specific exception for prisoners and those who shoot. You could gather as a group of more than 6 if you are attending a person giving birth at their request. There's a specific prohibition on raves among all outdoor music performances, and there are also restrictions that the organisers of large gatherings need to comply with, and restrictions placed on them. So 2 of the terms I said we'd touch upon, we're coming to now. The first relates to support groups. I'm getting a message that says I've got bad network quality, so it may be pointless me explaining that, but if things are breaking up, they should come back. The support group exception, that relates to groups organised by a business, etc., to provide mutual aid, therapy, or any other form of support to its members or those who attend its meetings. You see the examples of the categories of people who are catered for there, and those groups can meet up in greater numbers than 6, but no more, if we skip back to the exceptions, no more than 15. Then the sports gatherings exception to the rule of 6. An outdoor sports gathering is relates to those who are not elite sports persons taking part in any sport or other fitness related activity, organised by a business, etc., takes place outdoors, and the risk assessment has been conducted. And a permitted indoor sports gathering, similar, relating to indoor premises, and must take place at premises operated by a business. And so those gatherings can take place again in numbers greater than 6. So those are the exceptions to the rule of 6, dealt with to a reasonable amount of detail there. We're going to leave gatherings now and go to the opposite end of the scale and look at self-isolation, because for the first time there's been a legal requirement now outside quarantine returning from overseas travel restrictions to self-isolate if you're requested to do so. These came into force on the 28th of September, which is 3 days ago now. They were trailed about 30 minutes before they came into force, and then here they are. So let's see what they are. They're a little bit fiddly, but they're obviously quite important because they are likely to have consequences for a fair number of us, one way or another. So if you're notified by a specified person that you've tested positive for coronavirus after Monday's date, you're legally required now to self-isolate for 10 days. Specified person is the Secretary of State, although I don't imagine he'll be phoning around himself, an employee of the health service, perhaps slightly more likely point of contact, or an employee of a local authority. You see, local authorities referred a lot recently in the restriction regulations, and they seem to be getting greater involvement in it. We'll touch upon another aspect of that a bit later. So far so straightforward. You're told you tested positive for coronavirus, self-isolate for 10 days. It's not 10 days from the day that you're told you have tested positive. The 10-day clock can be calculated with reference to a number of different touchstones. So if you've reported symptoms, the 10-day clock starts from either the date of your reported symptoms or 5 days prior to your positive test, whichever is the later. So the 10-day clock could start 5 days before you're notified of the test result, assuming you're notified on that day. So you might only have 5 days of ongoing self-isolation. What that means, of course, is that for the previous 5 days, when you haven't been told to self-isolate, you've probably haven't been doing so. But there we are. The legal restriction is 10 days calculated in those ways set out there. If you haven't reported symptoms, then the 10 days starts from the date of the positive test. So there you are, looking prospectively for the full 10 days. Another obligation on you, if you're notified of the positive test, is you must notify the Secretary of State of the address at which you're self-isolating if you're requested to do that by the specified person. And in any event, you must notify the Secretary of the State of the name of each person living in the same household as you. Similar obligations apply to parents of children who tested positive. So the obligation isn't on the child, it's on the parent to do all of the above. The information you provide under regulations 2 and 3 may not be used in any criminal proceedings against you. Classic protection against self-incrimination provision, save for an offence under the regulations, because it's an offence of providing false information, or under Section 5 of the Perjury Act. So that is what you have to do if you are notified that you have tested positive for coronavirus, 10 days calculated in those ways. If you're notified by a specified person that you've had close contact after the 28th of September with someone who's tested positive, then you're legally required to self-isolate for 14 days. So a longer period of self-isolation if you've not had the test yourself but been in close contact. And that clock starts as set out there. If the person who's tested positive has reported their symptoms, then again it's the later the date of the report or 5 days prior to the positive test. If symptoms haven't been reported, it's the date of the test. So thinking about it, I suppose, if you're told you have to self-isolate for 14 days from today because someone you've had close contact with has just tested positive. If you were tested immediately yourself and tested positive, you would legally only have to self-isolate for 10 days from there rather than the 14. But there we are. There's the incubation period built in, which is obviously the reason why 14 days is picked for the close contact provision. Again, this person must notify the Secretary of State of their address if they're so requested, and similar obligations again apply to parents of children who are so notified. Well, that phrase close contact crops up there. what does that mean? Helpfully defined, Regulation 5, face-to-face contact with someone at a distance of less than 1 metre, or spending more than 15 minutes within 2 metres of an individual, or travelling in a car or other small vehicle with an individual, or if you're in close proximity to an individual on an aeroplane. So that is how close contact is defined there. And realistically, I think the way the notification is likely to work isn't so much somebody telling you you've had close contact with somebody as someone telling you that someone you have had close contact with has tested positive for coronavirus. That seems more likely to be the way that this works in practice. But then if you are so notified, you have that obligation to self-isolate. What does that mean? Stay at home, and that's back to essentially the old Regulation 6 under the 26th of March edition of the regulations. There are exceptions, and they follow familiar lines: urgent medical assistance, to go to the vet where that's urgent, to fulfil a legal obligation, and that's defined as including attending court or satisfying bail conditions or participating in legal proceedings. So that would certainly seem to cover a witness under summons, legal obligation to attend there, of course, or defendant who's on bail, or a juror, but probably wouldn't reach any wider than that. I say that because there's no general work exception, and so it would be somewhat surprising if the lawyers engaged in legal proceedings, or for example court staff, were required to breach the self-isolation rule, or were permitted rather to breach the requirement to self-isolate when no other category of worker was. That's the interpretation that Owen discussed it a bit. I would place on that, but it may be up for debate. You can also leave your home if necessary, having been required to self-isolate to avoid a risk of harm, to attend a funeral of a close family member, not a close friend, which was a previous exception to the original lockdown restrictions, just a close family member. You could leave home to obtain basic necessities where it's not possible to obtain these in any other manner. You could access critical public services, including social services, or to move from your home to the home of a friend or family member, or to bed and breakfast accommodation, only where it's impracticable to remain at the home address. So I guess if there's a flood or something of that nature, a problem associated with the address. That's not a moving house exception. That's an accommodation issue exception. So those are the exceptions to the requirement to self-isolate, we're told to do so. There are also work-related obligations contained in those regulations. Employers must not knowingly allow self-isolating workers to attend any place for work. And the corollary, the employee must notify the employer of the requirement to self-isolate, including the period for which they have to self-isolate. Similar obligations are placed on agencies and agency workers within regulations 7 to 9. And new offences have been brought onto the statute book to cater for breach of those regulations. Section 11, so regulation 11 that should be, it's an offence to contravene any of the requirements of those regulations, including the requirement to self-isolate. Broadly speaking, there's an unlimited fine upon prosecution for any of these breaches, but broadly speaking there's a fixed penalty notice for the first offence of £1,000, then doubling and so on. Slightly lower penalties for workers who fail to notify. There's an aggravated offence as well, which is contravening the requirement to self-isolate and recklessly coming into close contact with another group, being reckless as to the consequences for their health. And the fixed penalty notice for that starts at £4,000, which is quite a staggering sum for a fixed penalty notice to be levied at an individual. But it is, in the context of the public health crisis, one could see quite a serious offence. False reporting or providing false information about somebody else is also an offence under the regulations, and prosecutions can be brought now either by the local authority or the CPS. Previously it was only CPS or those authorised by the Secretary of State, but the local authority has power under these regulations to bring prosecutions for breach. So a slight change there. And that, with 2 seconds to go to 30 minutes, is a complete whistle-stop tour of the nationwide restrictions updates. It is, on any view, a complicated picture as time progresses, particularly when one factors in regional variations. And I don't know how many of this audience of millions that I have tuned in right now is in an area that's under local lockdown. But the key point to take away from this really is follow the public health advice. That is tolerably clear. The link there contains the latest advice. Further changes, of course, are likely in due course. Hopefully the next phase will be a relaxation, because that will mean things are getting better. All the slides will be made available at the end of the webinar. Any questions may be better answered by email, unless we've had any come in very quickly now that I can deal with. But other than that, I will hand you back to Andrew. If I can stop sharing my screen.
Thank you, Dominic, and thank you also, Julian. But more importantly, thank you for joining us. That brings an end to today's webinar. We will be back next Thursday, the 8th of October at 5 p.m. Until then, stay safe and goodbye.